Let me just go very briefly through. I mean, we have got the introduction I can skip because we had on the admissibility, the framework, the manifest, the grounds for review, which are quite interesting because, I mean, we have to make the distinction between the procedural requirements and the substance. The manifest error test, then I would ask Vincent to plug in with the case studies. And then at the end of the day, seeing how much time we have left, we talk a bit about the appeals to the Court of Justice and interim masters, but very shortly. Well, one of the major points is, and I think we had this already in the discussion beforehand, we're dealing with competition law. Also, it's between the member state in predominantly and the Commission, and of course an interested party. But we should never forget that we have to, in state aid law, we are part of the competition law family. And therefore, I think whatever we will see in manifest errors later on has got also kind of impact with regard to competition law in general. If we talk about 101 or 102, we will see a lot of issues which we can also connect to, and specifically also on the evaluation of facts. So, but let's come later to it. The other very important issue, just to keep in mind when we talk about the merits, we have also to see that state aid law is also a bit of political law in the various issues. I won't say that there is a result in a kind of broad discretion without framework to the acting authorities, but at least there is a kind of granular how far they can go, and probably the courts in the past, let's see that later on, have supported this kind of discretion, especially of the European Commission. Probably the coin is changing now a bit, but let's see what we have seen in the past. I think there are definitely some issues, especially when we talk about manifest error tests, where we have to be clear that let's keep in mind that there's a kind of political element into it. As I said, I will skip the introduction because on the issues of procedural we have just discussed, I hope quite substantively. In general, what are the grounds for review? I mean, pretty clear grounds of review, might be clear the lack of competence, the infringement of an essential requirement, infringement of the treaties, principles, or any rule of law relating to the application or misuse of powers. This is very broad, so we have to break that down. And including, and that's the key issue, there must be a manifest error of facts or on the law, legal interpretation, or failure, and that's also very important, to provide sufficient reasoning, because there have been cases in the past where the Commission has simply not given sufficient reasoning for their decision, and then in the end of the day, that was a reason then also for, say, there is a ground for review and you can plug in. Very important as well, and also we raised this already in admissibility, what are the pleading requirements? Because that's very, very important. Again, coming back to the notion of competition law, what as a complainant you have to bring forward in order to be heard? How substantiated? What is your burden of proof, so to speak? What you have to demonstrate? That you have not only to be taken serious, like in the extreme case of Werner, but to be really heard with all the facts. How deep you have to do the analysis, and I think we will later on in the case study see how, let's say, meticulous sometimes one has to be, how detailed one has to sometimes be. And here I think in grosso modo we can say that whatever you bring forward with the review of the merits, it has to be of substance. Yeah? So just if you don't talk about, if you don't read, if you don't bring your facts forward and think, okay, there is a commission, the commission has much more power to investigate, or had power to investigate, and they will take it for granted, it's not working. It's always the complainant who has to bring forward as much as possible in order to substantiate the case and to substantiate also on the reviews of merit. So the legality, all the issues you bring forward, you have to substantiate. Apart from one thing, as I've mentioned also in the overview here, if there is, of course, an inadequacy or simply an absence of reasoning when the Commission has simply left out a certain argumentation which would have been needed, well, then the court might have to think about and can see it themselves. But be totally honest, also there, my recommendation would be go and speak about it in detail, because in the end of the day, you have to bring everything forward in order to help your case. What is the scope of review? Well, I mean, Article 107 and 108 are not easy to digest. I think that statement can be made. And not easy to digest because we have got it to do a combination of economical facts and as well competitive situations, as well as reasonings and so on. So the factual and the economic appraisal plays an enormous role. And you have to see that because the Commission has been granted by the court, and we'll see in certain cases later on, quite a relatively wide discretion. In order to close this discretion, again, you have to make the story concrete. You have to make the story complete as possible. Again, don't believe because the Commission is on the other side and this is a legal institution that will take it forward. No, I think it's up to you. And in addition, one never should take out one thing into consideration. The courts are normally not so happy to deal with the factual, commercial, and economical side because simply, let's be totally honest, they are not experts in certain issues themselves. They are lawyers like predominantly ourselves. And sometimes we do not have the economic assessment right at hand. And we need colleagues, which sometimes are not in the courts themselves. So from the very first beginning of the complaint, be complete in your, as much as possible on the factual matter side and on the legal economical side, especially when later on we have to talk about private investor test or MEOP. Of course, you can always bring forward the legal argumentation. That's pretty clear. But I mean, the main issue is, I think it's specifically in the competition law cases, like let's say these cases, deal with the facts and deal specifically also with the economic situation. The materiality of error, that's a very important point, because that's in the end of the day what the court will decide on, or has to decide on the end. There must be a material of error who will then come to the conclusion, or with the help to causality, you come to the conclusion that the decision has to be a null or not. If there is no material error to be found, well, again, we see this later on, then of course the Commission can, not the Commission, then the court can more or less close the case. What have been decided as error cases, and I gave you a bit here of the overview. Well, the misapplication of Article 107. Let's be totally honest, it's a relatively old case. I think we will see less and less cases of that. So the erroneous application of the selectivity principle with a growing number of case law, with a growing number of principles that I think we will have less of that. Very important thing is the general principle of EU law. And I gave you here a very interesting case, the legitimate expectations, which you know has got two angles. It's a legitimate expectation on the level of the EU member state and on the level of the EU institution itself. And I think what has been really not tested sufficiently, we have also now the Charter of European Rights now. So probably there might come also be a kind of reassurance come back to this. Again, in competition cases with a certain question mark, but regarding, I mean, this is a general principle of law as well, so I believe one should actually look for much more cases with regard to the Human Rights Charter than probably in the past. Well, omission of a legally relevant matter. That's a very, very straightforward case, because in such a case, the Commission wouldn't have had the homework. And there have been cases in the past, one of them we will also cite later on, the Smurfit Kappa case, where the court was simply saying, look, here the Commission has not dealt with this properly, didn't do the analysis right, or let's say not in depth enough. I think this is a very important point, especially in the scenery we have got here. The Commission is responsible for a sound economic evaluation. And if there are obstacles, if there are omissions, if there are, let's say, inaccuracies, that is, from my point of view, one of the major points where you could have a relatively good point of error of law, material error of law, where the Commission can be caught on. Of course, other errors of law, the assessment of aid, for instance, and the timing factor of the grant. But I mean, from all of those, I think the omission of legally relevant matter, I think, is the, in major part, one of the key issues. We spoke, of course, about, or Leah has spoken about the procedural side, the procedural right. I think what is very important is, again, the question of burden of proof. Of course, whatever you bring forward, and therefore I really inflict on that, you mainly have got the burden of proof after the Commission has done, as long as they have done a proper evaluation. It's up for you to bring counter-arguments on the economical side. Very difficult are those cases which we have also in our discussion. I mean, the failure to open a formal investigation. It is pretty difficult simply because, as I mentioned before, there is a certain discretion and accepted a certain discretion by the court for the Commission to do that. And the Commission will find its way, be it on the more, let's say, procedural side, be it on the merit side itself. If they really do not want to open a procedure, they will find a way. So, again, the only way how you can frame this is bringing as much as possible forward to make their life difficult in order to get it not so easily with their discretion done. But again, it must be quite sound that they do not open the investigation. There must be a sound reason on this. Fundamental rights, ground for review, principle of law is the breach of rights of defense. Of course, if you as a claimant didn't have the sufficient rights, you were not heard sufficiently, your argumentation was not evaluated in a kind of investigation, then of course I think you have a good point and a causality that you might have been not heard enough and that you have got a breach of rights of defense here. But it must be, again, coming back to the argument what we had in the session before, it must be raised by the party directly concerned. So, again, if you are not being your own advocate in this, that your right have been defended, another side cannot bring it forward, be it the member state or someone else. You have to prove it yourself. If you are not doing to do it, then I think you cannot be heard. Well, the very much of importance, from my point of view, is the breach of duty to investigate. For two reasons. First reason is that a lot of member states, in the cooperation or non-cooperation or not sufficient cooperation with the Commission, will not grant the right or let's say sufficient information themselves. So breach practically their own in their own obligation vis-à-vis the Commission. However, the Commission, as it has got an impact on third parties or will have an impact on third parties, cannot stop there. They have to use all their measures in place in order to investigate as much as properly. So they cannot just rely, we didn't get the information, we have to stop. They have also to try then on the Commission side to really investigate it in deep, because it is not only the member state who has been impacted, it is also then the third party behind that. Review of facts, and therefore the case study later on will be of enormous importance. So he said, we need to have actually accurate, reliable, and consistent information in order to evaluate a competition law case. If we do not have this, if the Commission does not have this, then I think it will be very, very difficult, and in the end of the day, it is a breach as well if this is not evaluated correctly. Here we have to see how deep. I mean, in former times it was more or less said that the main driver is the Commission here. And the main driver is not the court, because the court is normally reluctantly to that. That might shift now a bit, and the two cases we will hear about where we demonstrate that I think, especially Ciudad de la Luz, which is a quite recent case, and will demonstrate that the courts are getting more and more interested in these facts as well. However, it is not only sufficient to establish this kind of facts. You have also to prove what kind of cause it had to the case, on the decision, what kind of implication and causality it has, in order to see that there's a material error of fact. Again, the Commission is dependent of what the ingredients specifically on national law and procedure. Also here, she has two ways. She can go via the member state. I myself had cases where the member states were not always so accurate for sometimes obvious reasons. If you want as a claimant to be correctified, you have to bring that forward. And it must be also clear from what you bring forward that that has got an impact, that the national law issue have got an impact. I found it very interesting when Leo spoke about the tax law. If you take into account that the majority of state aid cases, and we will even see more state aid cases now if you see about the tax investigations in certain companies, will grow significantly, that one has really to make clear what are the implications of tax rules and what are the impacts and what are the scenarios behind, because as a matter of fact, nobody else than probably the ones in the international member states can fully understand the tax law, and probably even them sometimes not. It is very specifically difficult for the Commission to always get the right thing. Again, it's to advocate here there should be a kind of full analysis of data. What is about issues when you raised concerns with the Commission? So factual issues specifically. So when the Commission by itself has already corrected, and then you say you go to court and say, look, I mean, the Commission has originally made a mistake. In the meantime, it has been corrected. Here it's pretty clear if the correction of the factual base, of course, come to in the end of the day, to a scenario that the decision is not valid anymore, well, then it's pretty easy. But quite often the Commission will say, yes, there might have been a mistake, but it didn't cause a kind of change of our impression of the case and our merit on the case. So one always have to say, if you have got a situation like that, in what way it would have changed the Commission's decision on the merits. Would they have had the correct factual information at hand at the first time, and not having corrected it only in the later past? Again, that's something to be provided for. Reasoning. As I said, there are more and more cases where the Commission also is under scrutiny for not giving exact reasons or not sufficient reasons, because that's the key obligation of the Commission, especially in competition law cases where you have you see that what kind of analysis was been done. You have to see what kind of combination the Commission has taken into account in order to come to the remedies. Specifically, when there are issues on stake, sometimes if you have aid or if you have not aid, you have to understand this. And that's not always an issue which is quite light-hearted, because it can decide over the existence of a claimant or not. So there must be a substantive legality of the measure. I think that's a very important issue as well. So you have to bring forward the issues why the reasoning the Commission has given specifically are not sufficient in order to justify the case and to justify the merits of the case. We spoke already about the level of detail. I think that's a key issue nowadays. We have to bring more facts over. We are not in the times anymore of the 70s and the 80s where relatively little factual background really, where the focus was much more on the legal argument side, because state aid law was quite new, was not, for instance. I think we have a pretty good legal framework now. But what is more important is getting more and more important, more and more, is really the factual preparation and the economic reasoning, and to see that this is the discussion going on. Pretty clear. Contradictions can be also fine. Nobody is perfect. Also, the Commission is not perfect in their analysis, as the national courts are probably even more unreasonable. You have to see that there are no contradictions in all. If, then you have to make it clear, especially also on inconsistency. A very, very difficult point, and I have to say, at least in the last couple of years, I haven't seen any case where you can really put a misuse of powers anymore, where at least the institution, especially the Commission, is just not taking care of something adoptedly, or is really ignoring arguments brought forward and not taking into consideration. It is very, very difficult, however, to see also such a case to prove that there has been a misuse of power, which in itself can be, of course, an argument on the merits, but it's very, very difficult to establish. Well, here's the place where I would like to hand over to Vincent, because Vincent has got some very interesting case law case study on the, well, what we former times called the private investor test or the market economic test, where it demonstrates how necessary a good and detailed factual background analysis and economic analysis in order to win the case.
Yeah, Michael. Thank you for this introduction, exactly setting the scene for what I was planning to do. So with this context, I thought it was probably nice and also a good idea to go into some cases in more detail to see how in practice this works out, and in particular sort of the evidentiary requirements that seem to be coming up more and more, I would say, in court proceedings. The theme of the session in general is judicial review of state aid decisions and state aid issues. Of course, I think it's relevant to bear in mind the distinction between the two parts of Article 107, 107.1, 107.3. I think very much of, let's say, the enhanced scrutiny of the courts, I think is going on at the level of 107.1, where indeed there's much more the factual question that is relevant, and then the next question, of course, is, you know, how deep should one go into the facts, and to see whether those facts indeed are consistent, supporting the conclusion drawn by the Commission, for instance, in Commission decisions. So there we see, I think, at least in a couple of recent court rulings, a quite detailed review of what the Commission has done, or the state aid question that has come up. By contrast, in 107.3, so compatibility, there obviously one is more in the area of a certain appreciation of the extent to which state aid should be approved and should be deemed in the common European interest. And that is a more political question, where I think there's clearly much more leeway for the Commission to take decisions, even still within certain bounds. In 107.1, I think most of the attention, as far as I can see, has gone into the market economy investor principle, market economy operator principle. By contrast, much less scrutiny has gone into other questions or other parts of 1071, in particular, what is the distortion of competition, what is the effect on trade. There, things are much more almost assumed, I would say, and certainly by the court. Maybe a little bit less so by the Commission nowadays, where the Commission takes a couple of decisions saying that there has only been a marginal effect on trade. Maybe there things are a bit more still ahead of us. 1073, there the discretion of the Commission is larger, but still bounded by guidelines and frameworks in particular. Now, to make all this a bit concrete, I thought let's zoom in on 1071 and in particular the market economy investor principle with two fairly recent cases. So one is the Spanish film studio case, Ciudad de la Luz, where the court rendered judgment in 2014, and let's say more recently in the Slovak case, Frucona Kosice. And well, I think my reading, but almost any reading of these rulings would suggest that yes, the court's review is becoming increasingly exhaustive, complete, or full. After all, it's a full review, but there's probably a degree to which reviews can be full, and the review seems to be getting fuller. Certainly, if you compare it to many cases of the 80s, 90s, and so on, I think it's, the judgment is, or the comparison is quite clear. So let's go into these two cases. I hope it will bring up a couple of issues. So the first case is the Spanish film studio case. That was a case involving public funding by the region of Valencia in Spain to set up a film studio complex. And so you see a couple of pictures of the film studio complex when basically it was largely completed, so it's there, you could say. It was brought about, it has been even operating. The timing of the case is quite elaborate. I don't need to go into everything. It's a fairly long story, which is not uncommon for state aid cases. So, I mean, there was clearly a plan by the Valencian regional government. There were business plans that underlied this project. The project was sort of launched in 2000 with a little bit of initial funding. Construction started in 2002. Changes were brought about to the plan, to the business plan, and additional funding in 2004. In 2005, the studio was sufficiently completed to start filming. And only in 2007, let's say, complaints came in from large film studio competitors at European scale. And you can imagine by the scale of this complex that this is not a small film studio complex. This is one of the larger ones, one of the top 5 film studio complexes in Europe, competing with Pinewood, Babelsberg, Carrera, Cinecittà. Now, the Commission opened a formal investigation in 2008, issued a negative decision in 2012, and then this decision was appealed against by Ciudad de la Luz and the Spanish government. The court gave a judgment in 2014. Zooming in on the financials, probably we need to know all this before we can sort of make a bit of a review of what the court said. It was clearly a large investment by the public authorities, 274 million. Now, as we all know, to the extent that the public investment has is profitable, it could be that indeed this is something that also a private investor would have been able or be willing to do. And if that is the case, then this public intervention does not constitute state aid. So the critical question, obviously, as in many of these cases, is the question of profitability. How profitable was this studio complex going to be? Looking at it from, let's say, the perspective of 2000, when all this started. Business plans were presented by the Spanish authorities, reviewed by the Commission, and in order to sort of see how profitable is this, what measure was being used, well, that was the so-called internal rate of return. It simply says, okay, you invest something up front, in the beginning to construct everything, and then you expect revenues, profits in the many years that come after. And if you sort of wrap up all these flows of cash, you can calculate on that basis what is the return on investment that was made or was expected in 2000. Now, the return of the project was expected to be, according to the business plan at least, of the Spanish authorities, positive, 8.84% in the 2000 business plan and 5.74% in the sort of revised 2004 business plan. The Spanish authorities on that basis obviously said, well, clearly this is not a loss-making project at all. We will be seeing a return, one which is positive. But of course, for the market economy investor principle, that's not enough. One needs to know whether the return expected, not only whether it's positive, that's the bare minimum, one could say, but also whether it was high enough for a private investor, considering the risk of the investment. Because not every investment is as risky, so for more risky investments, you would normally require a higher return before you would step into the project. And this is referred to as the cost of capital. That's the minimum return that any investor would require for investment projects of this kind, of this type of risky projects. And it's only if the return that you expect is higher than this threshold, than this cost of capital, as it is called, a private investor would indeed go for the project. So everything, I would say, almost turned, in this case, around the question, the returns, how do they compare with the cost of capital, with the minimum required by private investors? Now, in this case, the project was fully equity financed, so you would normally look at what are the returns requested by equity investors. You also have debt investors, banks, for instance, but this was a purely equity financed project. And so you would need to sort of compare that with what is then the minimum required by equity holders. And for that, the Commission applied, let's say, a standard model in corporate finance, which is referred to as the CAPM model, Capital Asset Pricing Model. And basically it says that, well, the return that investors require is typically the sum of two things. On the one hand, let's say a sort of a base rate, the risk-free rate, the rate that you will also get if you invested your money in let's say, government bonds, which are safe, let's say, plus some premium, reflecting the riskiness of the investment. How can you calculate this premium? Because you can't always see direct comparators or direct benchmarks. One way to do it is to say, let's look at what is the market risk premium, which is sort of the difference between what you expect on average to get on the stock exchange, for instance, compared to the government bond, multiplied or corrected, let's say, by what is referred to as the beta factor. And the beta is sort of a factor, it's 1 if it's a project of average risk. It's above 1 when it's a more than average risky project, and it's below 1 when it's a less than average risky project. And the Commission basically applied this methodology, looked at what is known about this sector, what are typically required rates of return on equity for investments in this sector. Now, this slide sort of compares the findings of the Commission versus the submissions by Spain. So if we sort of look at the three components of this CAPM model, okay, on the risk-free rate, people agreed, Commission, Spain agreed. At the time, 2004, I'm looking now at the second business plan, the 10-year government bond rate in Spain was 4.1%. Okay, so that we could take as a starting point, at least the return on investment of this project should be higher than that. But of course, there must be also a risk premium. And here there was a big discrepancy between, on the one hand, what the Commission and Spain thought to be the average risk premia applicable in the stock markets, for instance, and also the beta, which is the more specific risk factor applicable to investments in film studios, or in the film sector at large, if you like. And this gave therefore very different estimates of what was the cost of equity, sort of the hurdle rate for the minimum rate required for investments. Here, the Commission said the minimum is probably 14%. Spain said, no, the minimum is 5%. Well, the Commission said your expectation, I remember, which was 5.74%, if I remember correctly, that was in the business plan. That 5.74% is way below the 14% that any private investor would require. And on that basis, the Commission took a negative decision in 2012. Not only on that dimension, it also did a couple of sensitivity tests, if you like. I can come back to that later if time permits. Let's go to the court judgment now with these facts, with this context in mind. Spain appealed against the decision, and but the court upheld the Commission's decision. And I think it's a nice judgment to read. Maybe I'm saying this partly as a former Commission official, so please discount my judgment on this. But I think it's rich anyway in the topics that it addresses. So the court first spent quite some time on the methodology. So maybe it's a bit too much to sort of go over them one by one, but Spain had also said that, if we look at average rates of return, observed rates of return in the sector, 5.74% is actually not that bad. It's actually quite good. It's more than what we've seen historically, let's say. Now, the court said, well, this is somehow an average return that you have seen over the past years, but, that's one indicator among many. Probably you need to go more specific. And indeed, the Commission had said that, and also the court, I think, followed that, just comparing with recent or historic returns, that doesn't say very much, because you may have a sector in decline, the steel sector, for instance, at the moment, or television sets, old style, there are clearly sectors in decline. And what does it mean if your return is higher than what you see to be the return in a sector in decline? That is not the basis on which private investors take their decisions. They want to simply have a decent return, not something that is better than a bad result. The CAPM approach, in principle, is valid. There was quite a lengthy discussion of CAPM and the principles, but the court clearly hooked into the message that, yes, you have to somehow compare what you expect with the opportunity cost of capital, which is what normally is required. And this opportunity cost of capital is somehow, let's say, a base rate plus a premium. Court also said having consultant reports supporting your case, supporting the business case, is not enough. Spain had actually two business reports, certainly one of a very big name, like a big household accounting consultancy firm, and but despite that, and that report showed sort of a sufficient profitability, but the court said, sorry, a private investor would still critically review these reports. So you can't just wave and point your finger to something that some other people have written. Sensitivity tests are important. Okay. Now, on the standard of proof to which Michael already referred, I think the last bit is interesting. The court said that yes, the Spanish authorities, or let's say the public authorities in this case, being or contemplating an investment, they have a certain margin of appreciation as to whether something is likely to be profitable or profitable enough. Because that's also what the Spanish authorities had said. This is not a scientific exercise. We have a business plan that looks, let's say, 10, 15 years ahead. This is not always clear-cut. Spanish authorities went along in that reasoning quite a bit, but especially on, let's say, that part of it. So the fact that, yes, if you make your prediction about future sales, future costs, yes, there, maybe you want to be or you need to be fed and rely on maybe accounting consulting firms or business people. So there, indeed, there's quite some margin. But however, when it comes to the other side of the equation, comparing the returns with the cost of capital, so what is required normally, the margin is actually not so big, as it is possible to make comparisons with what alternative investments would render, what private investors normally require for investments of this kind, which you can find in investment bank reports, which you can find by applying the CAPM model. Now, on the precisely the application of the CAPM model, that model relies on a couple of components or parameters, you might say, and one observation was that the Commission probably did a better job, or a good job, I should say, in using sources that indeed were quite relevant to the case at hand. Now, what was the case at hand? A film studio, so film sector, and Spain. So you need to sort of zoom in on these two dimensions at the very least, and then say, okay, this is the minimum required return. Whereas Spain had sort of been pointing to more generic benchmarks of more general European returns, etc. The Commission also relied in part on two investment reports on two close competitors. So we are really close in terms of the activity. Babelsberg, Carrère, which are two film studios, which is more precise, if you like, than what Spain had been using. And also what I found interesting, because you always sort of hear the sentence like the court will not substitute its own assessment for that of the Commission. Probably it didn't. I'm sure legally it's all safe, but there are statements of the kind that, it says Spain's estimate of beta cannot be correct. I'm paraphrasing, but this is more or less a finding, because it says, the court said, it signals a risk profile that is even lower than the market average. And the court clearly said, well, film studios, this doesn't strike me as a average type of investment, or let alone a more conservative investment than the average investment in the market. On the business plan, that's also interesting. I thought there the Commission took the business plan of this film studio at face value, so it didn't quite question, those sales levels and cost levels 10, 15 years in the future. It took those as given. It just said, okay, this gives me a return, and let me compare it with the cost of capital. And all of the Commission's work went into that comparison. And the court said, but the Commission did say, okay, we're not quite sure whether all these assumptions are good. Maybe they are a bit too rosy. But the Commission didn't sort of dig into that. The court recognized that and said, okay, this looks like a conservative approach. The court also went on to say, obviously because the Spanish authorities brought it up, that actually the Commission got it still wrong in the sense that it had not recognized that probably there would be some more revenues from this whole project in relation to a hotel complex that would be built later on. The Commission had sort of not taken that into account, basically. But interestingly, and I think, this is what Michael also said in one of his slides, yes, the Commission can make an error, or the one who's making the claim here can make an error, but given that it doesn't make any difference, and that is what the court observed, it sort of made its own calculation almost for that purpose. Given that this error would not make any difference, that would not be a reason for annulling this Commission decision. For the sake of time, let me move on to the second case. And then, by the way, I'm happy to take questions and comments. I think there's more like a specific session or time slot afterwards, but so I'm happy to, looking forward to any comments or questions that you have on this case or the next one. Another case that also illustrates how detailed things can get, and also, let's say, how detailed the court can get, because that's the topic of today, basically, in its assessment of MEIP cases, is the recent Frukona-Košice case. That was the application of the private creditor principle. So there you could think of the public authority as being a claimant, a debt holder of this firm, which produces spirits, as you can see. It's a Slovak company. And here there was actually a build-up of excise duties related to the spirits that this company was selling. Somehow there was a increasing stack of excise duties still to be paid by this company. It always received a couple of deferrals in time from the local tax office. But at some point, the tax office no longer really could accept these, and then the firm filed an application in the local court proposing to its creditors, which was mostly the tax authority. More than 90% actually was tax debt. So the offer was that they were paid 35% of their claim. And in fact, the creditors, also the tax authority, accepted that proposal. Interestingly, by the way, you will see that this is yet again a case with a long history, sort of a typical state aid case in that sense. In 2004, however, the same year, I'm not quite sure either the tax office or the authorities of Slovakia sort of got cold feet and thought, oof, we have now given up 65% of our debt claim. Is this not state aid? Perhaps we should notify, and actually they did. And they even notified the measure as a rescue and restructuring aid. So you could say, clearly showing that this was not MEIP conform, but rather understood to be aid. And this was a bit of a interesting twist to the whole case. Commission took a decision. It said, okay, this is aid because you say so. Well, more or less, one of the things said by the Commission. Incompatible because there was not a rescue and restructuring, there was no restructuring plan, etc. So the usual conditions didn't apply. Decision was appealed, General Court upheld it, but then the Court of Justice set it aside. Lack of reasoning, incomplete reasoning. I'll come to that a bit later. I think it's better to do that then. The Commission, given that the Court of Justice had set aside the ruling of the General Court, instead of waiting the new ruling of the General Court, said, okay, let me just rectify these omissions, and that's it. It's still incompatible aid. But again, there's an appeal, and the General Court annulled the Commission decision just this year in March. Now, first of all, the court makes a couple of, it's a very lengthy judgment, by the way. The court made a couple of interesting points, I thought. First of all, and here, by the way, I would welcome maybe Michael's or anyone's views on this. There's a bit of a lengthy discussion, which, by the way, also came up in Theodat Laluth about, on the one hand, the applicability of the market economy investor principle and the application of the market economy investor principle test. And even if I can understand probably what this is about, I still have the impression there's so much overlap between these two elements that sometimes it gets a bit confusing to me, being not a lawyer. So I'm happy to park that with lawyers. Anyway, so when this is about the applicability. When a member state says that it acted as a private investor, it should also show clearly that at the time when it sort of transferred the resources, it took this. It took beforehand a decision to do this, and also in the way it did. So it should be sufficiently concrete, and produce evidence showing that the decision was based on economic evaluations comparable to those which, in similar circumstances, a rational private investor would have carried out in order to look at the future profitability. economic evaluations made afterwards do not suffice for this purpose. So here it's very clear. My question mark comes a little bit when the court seems to say in this judgment and also in Theodore de la Luz that when it then comes to the application, then somehow reports produced afterwards can play a role. Anyway, the burden of proof of the assessment lies with the Commission. And this is interesting because, remember, this was a case where Slovakia itself notified the measure saying, well, this is aid, it's rescue and restructuring aid. Despite all that, the Commission should have almost done as if that claim was not there and just looked at the facts and the objective facts of the measure, really to see, is this aid, yes or no? Why? Well, because there's not only the member state who has something to say, but also the beneficiary, and the beneficiary was of the view that this measure was, in fact, a market-conform measure. It did propose something that would have been acceptable to any private investor. So hence, the relevance of the Commission still just looking at, is this state or not aid? Now, as in many of these private creditor cases, a comparison somehow had to be made between, okay, the arrangement at stake, which was the 35% compensation, which amounts to a debt write-off of 65%, so the measure at stake, with the alternatives, and normally, very often, the alternative is just bankruptcy proceeding, and then, okay, the state as a creditor can see what it still gets out of the assets in the recovery procedure, bankruptcy procedure. Here, given that it was a tax authority, it had a couple of, let's say, legal shortcuts, I understand, under Slovakian law to sort of get hold of of the assets. But the principle is the same. The Commission had done that, and certainly already in the first decision in 2006, but also in the follow-up improved decision of 2012, the Commission did embark upon a comparison of, okay, what were the proceeds that this private creditor, hypothetical private creditor, would get in case of this deal, which is 35%, or what it would have gotten in the alternative settings. And the test, as specified by the court here, is that all these three options in this case had to be examined to ascertain whether a normally prudent and diligent private creditor would manifestly not have accepted the proposed arrangement. So there is a manifest error test which is clearly coming out of this language here. And the animal that we should look at is the normal, prudent, and diligent private creditor. And several factors need to be assessed in detail in making this comparison. And here you see several of them listed, also listed in the court judgment. So clearly it was relevant here that the tax authority was a creditor, but not just a creditor. Actually, it had been given guarantees, specific guarantees by the company in question. So already that made it a bit of a secured creditor, which is different from a normal, ordinary creditor. Okay, the nature and the extent of the security held, of the collateral. Of course, making the comparison, either taking the 35% right now or doing the alternative. Well, the alternative means not taking the claim and seeing what happens. Well, that depends on, well, maybe the firm will return to viability by itself, or it will go bankrupt, but you would need to sort of get an understanding of how close this company was to bankruptcy, I would say. The risk of seeing losses increase in the meantime. Obviously, the amounts received in case of liquidation, and then the duration of proceedings, like the bankruptcy proceedings, but also this alternative third specific tax route. Now, in 2006, the Commission had, according to the Court of Justice at least, had actually not really looked at this aspect of duration. The applicant, the firm in question, Frucona, had argued that it was clearly beneficial to take the 35% immediately, as opposed to a lengthy, uncertain bankruptcy proceeding, which could take very long. In the meantime, the assets might go down in value. And the Court of Justice accepted that the Commission had not looked into that aspect of the duration, or at least not sufficiently. So that was the reason for annulling it the first time around. Second time, when the decision took a new decision, it sort of corrected that. It sort of looked a bit more closely at duration, and then said, this duration, we estimate it to be this and that. However, it's not all that relevant in the end, the Commission said, because this is a tax office and it anyway has the status of a secured creditor. It can have a couple of shortcuts to basically monetize on the collateral that it possesses. But then, and that's then in the current or latest judgment of the General Court, again, of this most recent Commission decision, the Court found yet another defect in the Commission's decision, which is that basically the Commission had not investigated sufficiently the likely value of the collateral of these assets in case they would be sort of sold as a part of the either the bankruptcy procedure or the specific tax procedure. The reason being simply that, okay, you may have certain assets which are in the books of the company at a certain amount of money. So you can think of fixed assets. You can think of stock, so all these bottles of spirits and so on. Receivables that are on the balance sheet, even cash that is within the company. So there are different asset classes. And okay, cash is cash. So there you could say, well, if there is a, I'm sorry, if there is 100 of cash on the balance sheet, I can sort of assume I can probably get 100 out of it, minus 1 for the lawyers that have to be paid. But you know, with the spirits and the stocks, it becomes all a bit less clear, right? You know, what is going to be the value of that? And typically, what you see is that there is a discrepancy between the money that you actually can make out of this sale, which is sort of 1 year down the road or even longer down the road, and the way it's registered in the books. And interestingly, there were a couple of reports floating around. The company had made a report. It also had basically, in its context with the tax authority, had said, you know, this is sort of what I think it's worth, and the tax authority had sort of endorsed that in one way or the other by basically accepting the tax deferral. But the Commission relied upon numbers quoted in that context, both in the 2006 decision and in the more recent 2012 decision, so the correction decision, which was, 2014. But in the course of the administrative procedure, the Commission had actually not really asked for these reports. It had basically relied on the submissions of the claimant, of the company in this case, had actually even made a couple of adjustments, saying, well, this looks a bit optimistic, but it had not done some, let's say, autonomous digging into the facts. It had not asked for that report. And the court was, a bit tough, I guess, and said in this context that the Commission had not carried out any methodological or economic analysis and did not request during the administrative procedure additional information, Michael, you mentioned it as well, intended to verify and substantiate the so-called liquidation factors, this discrepancy in value. So on that basis, the Commission had relied on insufficient evidence as to the amounts to be received by the hypothetical private creditor, or the tax authority in this case, in case of liquidation. And then basically the same defect came up in the sort of third route, which was the more specific tax route, where on top of that the court had sort of merely assumed, that's the wording of the court, that the tax execution procedure would be conducted in a speedy manner, in particular when compared to the normal bankruptcy procedure. Now the court, I guess the Commission, I mean, this is my thinking or my words, I mean, the Commission may well be right. Seems somehow not illogical that maybe a tax procedure, a dedicated procedure is speedier than a bankruptcy procedure. So that's maybe not the issue in the end, but where were the facts in the Commission decision? So I think that by at least giving these two case presentations, and of course the question is always how representative is this, right? Certainly as an economist, but anyone should probably ask the same question, fine, so you present two judgments, is this illustrative of what's going on at large? Well, I can't make the claim that I've read each and every judgment, but I think, I have read a couple of judgments in the last 1 or 1.5 decades, and the sheer detail and questioning by the court is quite remarkable if you compare it with judgments of let's say the early 2000s. That's my impression, at least. It may be true that this is, and to some extent I think it is true even, that this is very much focused on MEOP, so the question of advantage. The other elements in 107.1, and I refer to one here, distortion of competition, effect on trade, is much more on automaticity still, I think also in the thinking of the court. But let's see whether perhaps things will change a little bit, given that the Commission seems to be, well, at least in the flavor of things, opening up a bit its approach on a particular effect on trade. That's the package of April 2015. Then on Article 107.3, not to spend too much time on it, but I think we can come back to it whenever there are questions. So there the margin of discretion for the Commission is much larger, even if confined within the guidelines. But also here, there are a couple of judgments from 2011, 12, 14, at least that I'm aware of, including, by the way, Ciudad de la Luz, where the court did, I think, a review of the argumentation provided by the Commission, where, at the very least, what one could say is sort of a plausibility test, I guess. So to give maybe one example, and then I will close there. Ciudad de la Luz, just simply because I've already explained the case a little bit. So there was the question of compatibility. Yes, maybe it's state aid, but perhaps it does serve a good purpose. And there was something about regional aid, but there we have regional aid guidelines, and it was clear that since this was fully financed by the public authorities, the normal requirement that there should be at least 25% of private contribution was not met. So hence, there was no compliance with regional aid guidelines. So that was clear enough. But then also the claim was made that this was anyway good for, let's say, cultural and other reasons. So a more generic assessment under Article 107C. D was also discussed, but this was about C still, where the Commission had applied basically the so-called balancing test. What are the reasons for the aid? Are the reasons good? What are the distortions, etc.? And so one of the points that came up here was, or one of the arguments was that there's a market failure in this sector. There's not enough, let's say, Spanish language film production in the EU. And then here the court was, following the Commission to a large extent, or to the full extent, I would say, at least. It said that, or it observed that, well, it doesn't quite seem that this studio is really built for Spanish language film productions, but rather there to compete in the European, if not global, context of attracting large film productions. And also the court, interestingly, said that there's no market failure. At least we follow the Commission's assessment here, because the mere fact that in some region or in a country even there is no film studio is in itself not a showing of a market failure. It may very well be a natural and good outcome of the market that, you know, you will only have a few of these film studios in Europe, and well, perhaps they are not in Spain, but that's not in itself a market failure. You may like it or you may not like it, but that's not a market failure. And so the court also followed the commission on that point. But okay, by and large, here there's a more remote review by the court on MEOP advantage in general. I would say the court's review is becoming increasingly exhaustive and full. Okay, thank you very much, and looking forward to questions, comments.